Hello, my name is Loukas Mistelis, and I'm a professor of arbitration law at Queen Mary, University of London. I'm also the director of the Queen Mary and Unidroit Institute of Transnational and Commercial Law, a project that I have moved to after having been for 17 years director of the School of International Arbitration at Queen Mary from 2002 to 2019. And in that period, I was also the first person to have an arbitration chair in Europe, at least. I'm delighted to be part of this ITA Academic Council series on what I'm working on. I have been associated with the ITA over several years, and it is a privilege and a pleasure to work with colleagues and to share my research projects. I'm going to refer today to two projects I'm working on, and these are projects that I would expect to complete in the next 12 to 18 months. The first project is a monograph, is a book, and I have been researching this book for quite some time. I'm looking at the evolution of the arbitrator as a profession. Arbitrators, perhaps up to the last quarter of the 20th century, they were a side profession. People would normally be professors, they would be legal practitioners, they will be judges, even government employees in some other occasions. And at the side of this profession, the main profession, they will be asked to sit as an arbitrator. And they will sit as an arbitrator perhaps in 20, 25 cases over their professional life. From the last quarter of the 20th century, we have seen that arbitration has fully emerged as a profession. People have given up the legal practice, they have given up the judicial career or the academic career, and they are practicing as full-time arbitrators. And therefore, they have also the advantage of doing that full-time, and throughout their professional career, they might be sitting in hundreds, perhaps, cases. That, of course, changes the dynamic of arbitration. Arbitration used to be an honorable profession. Remuneration was not a critical part of it. People were doing it on the side, and they were always delighted and flattered to be asked to act. But this was not something that was coming very often, and therefore arbitrators were not relying on being arbitrators in order to generate sufficient income. This change means that the expectations of the public and the expectations of the law from arbitrators, from people who now rely on being arbitrators to have their basic annual income, is much more focused. And of course, independence and impartiality is one side of that. Actually, I'm not addressing independence and impartiality at all in this monograph, because I think this is something that has been written quite a bit about. But I do want to explore what are the rights and duties and powers of arbitrators, and how these have changed with the evolution of the profession. And I'm using a series of methodologies. I'm looking at evolution theory, of course, historical research, and also market theories to see how arbitration has developed as a profession, and how arbitrators as professionals have evolved as well. I would expect to have this book published by the summer of 2022, if not earlier, but this is something that has been in gestation for some time, and it is a bigger topic, and I'm only addressing several aspects of that. The second project is part of a series of writings that I have been doing over the last few years, and looks partly on the reform of ISDS, but most importantly, trying to find a theoretical approach to assessing ISDS and where we are now and where we're moving. And in my particular approach, I'm using moral philosophy and Aristotle to justify the existence of ISDS as currently is, perhaps with amendments towards efficiency and effectiveness, and perhaps even consistency. And I think that if one looks at cases like Lowen, where the conclusion is that the investor might have been wronged, but the tribunal doesn't feel comfortable with exercising remedies under NAFTA, in that particular case, or an investment agreement, brings about a broader philosophical questions as to why we have investment protection and how this investment protection should operate. The economic analysis of that side has been done by other people, and even the international relations and the politics. But I think the moral philosophy approach, or the broader philosophical approach, is yet to be done fully. And this is part of a number of other projects that have been involved. In 2020, I have drafted, with a number of colleagues, also from the ITA, a policy brief for T20 that was ultimately submitted to G20 and advocates a more holistic approach to ISDS reform rather than just focus on procedure, but also a project that Queen Mary has done in 2019-2020, looking at investors' perceptions towards ISDS reform and what could be done and how that should be done. So the narrow topic I'm addressing now would be perhaps ready by the end of the summer. And with this project, and indeed my other monograph project, I would welcome any feedback that anyone would like to send me, either through the YouTube channel of the ITA or indeed through a direct email or other means of communication you feel appropriate. Thank you very much for listening to what I'm working on session.